We submit that this case fails at every level. Factually, the applicant failed to establish South African arrest or coercive conduct in Tanzania. Procedurally, no competent constitutional relief was pleaded against the Department of Home Affairs. Legally, the applicant conflates deportation with extradition, and jurisprudentially, the minority transforms ordinary sovereign deportation cooperation into constitutional wrongdoing without a factual foundation for collusion, deception, or territorial violation. The SCA majority judgment correctly refused to do so. We therefore submit that this application should be dismissed.
Ms. Mayet, here at the center.
Yes.
Thank you. Thank you. Can we just examine a certain scenario, and I'm interested to hear your comments on that. In this scenario, when you were making your submissions, you said that Tanzanian authorities had already decided to deport the applicant. And when the time came for the South African authorities to come to Tanzania, a decision had been taken and they were preparing to deport the applicant. Is that what you submitted? At least their minds were set on going ahead with the deportation. You said that. Am I correct?
Indeed. Justice.
If South African authorities had not arrived in this scenario I'm painting with you, would the deportation have proceeded without their presence in Tanzania?
Justice, we know that the applicant on her version had consulted with a Tanzanian lawyer. And on this scenario, if the...
Please, Ms. Mayet, if I can just get a yes or no, because I'm trying to try and understand the submission that you made.
So
that South Africa was not involved in this process. Tanzanian authorities had decided to deport, and they went ahead and dealt with the deportation. So I'm asking you now in this scenario, if South African authorities had not been in Tanzania at that moment, would deportation have occurred?
I would say no, Justice. And if I may elaborate why, because in order for a deportation to take place, you need verification of identity, and you need the country of origin to
be there in the country that wishes to deport. So in all scenarios, are you submitting that in all scenarios where a country wants to deport an illegal immigrant, the country to which that person wants to go must be there?
The country that the person wants to go must agree to accept that person.
Does it have to be present in the country to agree?
It does not have to be present in the country, but there must be agreement.
Then let's go back to our scenario then. Would the deportation have happened even if South African authorities were not there?
In the event that they had an agreement from South Africa that the applicant was a citizen, and confirmation and acceptance that then the deportation would have been able to go ahead.
Are you then submitting that in both deportation and extradition there has to be an agreement?
Indeed.
So there's no real difference between extradition and deportation?
The difference is the jurisdiction and the reason for the request. Deportation is a decision by the sovereign state in whose territorial jurisdiction the individual finds itself. And the expulsion simply needs agreement from the state to which the Tanzania wishes to expel the particular person.
So-
Extradition, on the other hand, needs a formal request, and it has a very specific purpose, because...
Okay, let me try and understand so far. I'm sorry to interrupt you. So saying that in deportation, you disagree with Mr. Katz that it can be unilateral. It has to happen with agreement of the receiving state. That is your submission. And that in extradition has to be more formal, but it also needs an agreement. Is that how you distinguish between the two processes?
So, Justice, how I am distinguishing is deportation, the decision is unilateral, the decision to deport, but a decision cannot be implemented without agreement. So
in all instances, if a country wants to deport someone, it has to make sure that it contacts the state where it wants to deport this person to. So it has to know to which state that person has to be deported. So it can't deport to a state to an unidentified state. Is that what you're saying?
Indeed, or a state that, if the person is able to get consent from any other state that agrees to accept them. So
Okay.
it's either the country of your origin is the first place for deportation, and next would be any other country that agrees to accept you. But you do need consent.
Okay, no, I understood it differently. I still understand it differently, but obviously I'm going to reflect on your responses. And Mr. Katz is here as well. He'll respond if he wants to. Let's move to a different thing. So you said that the South African authorities didn't have to be there, but in this instance they chose to be there, but they didn't have to. So the applicant would have been deported even if they were not there.
Because the deportation order was a order by escort, because she was ordered to be removed from the country by escort.
So the South African team went there to escort him?
Well, initially simply to identify her, and the Department of Justice, the Department of Home Affairs went specifically to escort her, because if we do not escort her, then if Tanzania escorts her, their custody of the applicant terminates as soon as their territorial jurisdiction ends. They cannot have custody. They only have custody and control over her while she's within their territorial jurisdiction. Outside of their territorial jurisdiction, they have no basis to take her anywhere.
Okay, let's move on from that then. The submission, perhaps I didn't understand you well, but you said that the minority judgment says that extradition is the only way to deal with an illegal immigrant. Is that the submission you made?
Yeah, indeed.
Can you please show me where in that in the minority judgment of the SA that is said?
Asked Tanzania to arrest her. She was not arrested because she committed crimes in South Africa. She was arrested because she entered Tanzania unlawfully and she was contravening their Immigration Act. Even the majority judgment of the Supreme Court of Appeal accepts this premise. And because once the arrest is accepted as a sovereign Tanzanian immigration arrest, the premise of unlawful South African coercive conduct disappears, because the arrest was made by Tanzania. The apprehension was caused by Tanzania. So the SCA then, majority judgment, then correctly applied Plascon-Evans. It correctly held that Zealands did not shift the onus, and it correctly referred to Mhlangu. These authorities matter because they establish that the onus only shifts once the identity of the alleged unlawful actor is established. And we know now that the applicant failed to establish that the SAPS arrested her or abducted her or exercised coercive authority in Tanzania. If it is the applicant's case that the Department of Home Affairs somehow unlawfully took her into custody, that cannot be, because Tanzania does not lose custody over an illegal deportee until that person is expelled from the state. So although they released her to us, they retained custody. Now I get to the majority judgment's misconstruction. The minority judgment, apologies, it is well written. It is concise, but it operates from a mistaken premise. It is this, that once a fugitive is involved, extradition is the exclusive lawful mechanism for return. This proposition is unsupported in international law. A fugitive has no constitutional right to demand extradition. Extradition exists for states. It is the prerogative of states, not fugitives. The decisive question is therefore not, was the applicant wanted in Tanzania? The decisive question is, why did Tanzania remove her? They removed her because she was an illegal, prohibited immigrant who had contravened their immigration laws. The sovereign immigration purpose, which Mohammed reiterates, and this court underpinned, that the purpose never disappeared simply because South Africa also wished to prosecute her. Now, we have cited many international cases in our heads of argument which underpin this, this principle that a state is entitled to deport a fugitive, notwithstanding that the fugitive is wanted in his country of origin. A case in point is Soblem, and therefore, with regard to the Supreme Court of Appeal minority judgment, it conflates deportation cooperation, which is necessary for the implementation of the expulsion, and extradition collusion. There is no collusion here. South Africa was not involved except in facilitating her return to South Africa. Now, I have dealt with...
There wasn't collusion because the Tanzanians and the South Africans didn't tell the court that there was collusion. No colluding parties will ever tell a court that they colluded. By definition, colluding parties are doing something that they don't want the court to know about. And that's why they make up this stuff about agreements here, agreements there. That's how collusion works. Can you imagine if collusion in criminal matters corruption? The corruption says, well, I didn't do it. Of course, that's how it works. That's what collusion's about. The second bit and bob. The third is we agree with Justice Majid's debate or the comments that he might have made, not that he made any submissions, but the question that he put, it is bizarre that Home Affairs can at this stage come to the court and say there's a violation of their Section 34 rights, Audi. If they had, and they can't point to any prejudice, and importantly, they had an opportunity in the SCA. Remember, the case got to the SCA on what we called petition in the old days. It's now called an application for leave to appeal. I think it's under Section 17. And in this court, they filed an affidavit in this court. And it strengthens the notion that they've had every opportunity to tell the court whatever it wanted concerning not only the so-called amended relief in the reply, paragraph 111, but also what Justice Makhoka found, JA, found in the SCA. They could have said in the affidavit in this court, well, it's true that there was amended relief, we were prejudiced then, but now let us tell you what really happened. They don't take up the opportunity even in this court. So that strengthens the notion of no prejudice. And it's bizarre that they should say so today. They can't point to it. I come to the big point, Chief Justice, and a difficult point. And my team have debated this up and down, and it arises from a question that, Chief Justice, you put to my learned friend for the police, which is the paragraph 116 of the minority judgment. And it's difficult. I'm not saying it's easy, but I'm going to make a submission on it, which really deals with Justice Collipin and Justice Savage's concerns that they put to me in my debate. The reliefs that would have been granted in paragraph 2.2 of the minority decision talks about no jurisdiction of the trial court. And Justice Collipin says, aren't there other ways in which the police could be disciplined, or the court could show its disapproval of what happened? If this is all on the basis, if you're with me. And Chief Justice, you put to my learned friend for the police, well, what does it mean if there is this notion of no jurisdiction by the trial court? And the question that arises is this, and the minority decision considers it. I abandoned the relief in the SCA, I can't remember whether it was the High Court or I can't remember when I did, that concerned the validity of the arrest warrants that had been issued in this country on the 3rd of April. That would have been paragraph 4 of the original notice of motion. I abandoned that relief. And obviously, I did so, and the minority said that I did so quite appropriately, because those arrest warrants were issued before anybody even knew that the applicant and Mr. Bester were in Tanzania. So the arrest warrants stand. The question arises like this. If this court upholds the 2.2 prayer and says the trial court, now the High Court was the Magistrates Court, doesn't have jurisdiction, is that the equivalent, Justice Collipin, Justice Savage, of a permanent stay? That's really what Justice Meyer was putting to me, as I understand, putting to my learned friend for the police. And the answer is this court doesn't have to go into that question. It's a difficult question because, for example, and we can think of many scenarios, this court doesn't know what will happen in the future. And remember, jurisdiction is to be determined at the time the case was brought from Akron, case from long ago of this court. But let's say, for example, and I can't think of many examples, but there must be possible examples. The court upholds it. Dr. Magudumana is released from prison, from the Kroonstad prison where she is now, and a week later she flies to Chile or some other country. The question would arise for the NPA and for the Minister of Justice, could they seek her extradition lawfully from that country? And I don't know the answer, and neither does this court. Because it may well be, Justice Collipin, Justice Savage, that it may be that an order of prayer 2.2 isn't the equivalent of a permanent stay in those types of circumstances. I can't think of, and either we've tried, we've thought about everything possible, we don't know the answer to the question. And this court doesn't have to answer that question here. It might answer the question if Dr. Magudumana does go to Chile and there is an extradition request and she comes before another court, and then we could point to this court's judgment of 2.2 and say it was the equivalent of a permanent stay. We don't know. But so this court can leave open that question, which we would submit satisfies the concerns that Justice Collopin and Justice Savage rightly put to me concerning the balancing. It's not necessarily a permanent stay. And it's a difficult question, Chief Justice and the other justices, but that we would submit would be the full answer to the difficulty of granting somebody who's committed, whether it's minor crimes, serious crimes, the most serious crimes, crimes against humanity, whatever it is. But that's where the real soul, if I can call it that, comes in to soften the distaste that people would leave with if the person is to be freed because of the government acting badly. And when my learned friend says it will be a dark day where this court it would be a dark day for this court to grant the relief. We submit it would be a dark day when the court, in the face of the evidence that is before this court, on the collusion, on the unlawfulness, we've heard the argument about Section 41, it'll be a dark day when this court reverses all the, what we would call those golden threads, that golden plait that I was talking about this morning, of Muhammad, Matsebe, of all those cases, Makwendani. That's when the darkness comes, not when the court continues that line of the golden thread. Chief Justice, thank you for allowing me the extra minute. Chief Justice, during the break, I gave